How are we doing, pre-lit family? Stephen Palmieri coming to you here today, and we are doing a follow-up video on the one from yesterday where we talked about how the FCRA was designed essentially to kind of restructure and to legislate defamation, truth, and to create procedures that the credit bureaus and that the consumers also are required to perform in order to stay compliant with the FCRA. Why we keep talking about this is because this is why many consumers and credit repair organizations feel like the credit bureaus are almost unbeatable, is because we're just not really understanding how the FCRA works. Again, for those of you guys joining live, go ahead and put in your comments below. I am watching those, and we are doing this for you. So let's go ahead and do a share screen here, and we're going to go ahead and just kind of jump right in and take a look at what we're talking about here today. So we've got the FCRA pulled up here, and just to recap yesterday's video, the first thing we're going to look at is 1681 EB, which is where the accuracy requirement for the FCRA comes in. Okay, this is the compliance procedures, and again, we're talking procedures here. So 1681 EB is the one sentence of the FCRA that requires reasonable procedures for maximum possible accuracy. The problem that most consumers and credit repair organizations have is they do not really read this with its counterpart, which is the limitation of liability. They just say, oh, they're supposed to report maximum possible accuracy. Well, if we look at 1681 HE, if we go back down here, this actually really is essentially what I would call the counterpart to the maximum possible accuracy. Because what are we doing? We're talking about the telling of stories, information. And if a story is not true, it's kind of defamatory, and maybe you're negligent, right? I mean, that's just basic common law principles of the American legal system that's been handed down for hundreds of years. So why is the FCRA requiring maximum possible accuracy? Well, they're basically saying this law assumes that the consumer reporting agencies and the furnishers are going to start from a position of telling truthful stories, essentially, and reasonable procedures to assure that it is a maximum level of truthfulness. Because of that, what Congress said essentially is that the consumers no longer have the right. As soon as the FCRA was passed, they took away the common law rights to claim defamation, invasion of privacy, and negligence, okay? Except unless the consumer can argue that the information was false and furnished with malice or willful intent to injure. This is the counterpart to the maximum possible accuracy requirement that most people just overlook. So prior to FCRA, if a consumer got damaged, felt as though they were wronged by a consumer reporting agency, they would go find themselves an attorney, and the attorney would typically wire together some sort of a lawsuit focused on these three primary causes of action right here. There may be some other things as well, but typically, if a credit bureau told an untruthful story, there was either going to be defamatory. They were maybe invading your privacy, or at least at a minimum, you could say they were negligent for not doing their due diligence to tell a proper story, right? So what Congress is saying is that, hey, we're under the law that Congress is passing, we are removing the consumer's ability to invoke these common law remedies, taking it away, no longer possible, because Congress has now said that these are no longer applicable, unless, of course, it's false information furnished maliciously. But instead, we're also saying that we're going to assume and put reasonable procedures in place for the consumer reporting agencies to assure maximum possible accuracy. So there was a give-take there. They took away these remedies from the consumer, but they also placed in the statute the requirement that consumer information, we'll go back here to EB, the requirement that this information now under the statute must be maximum possible accuracy. Okay, so these two things come together, and so if they took away the remedies of defamation, negligence, and invasion of privacy, well, what are your remedies? Well, now your remedies, which were created under the FCRA, typically are negligent and willful noncompliance, your 1681N and 1681O. And we don't really need to read through all these, you guys can, but essentially, it now in the FCRA itself says, the language of the FCRA right here gives authority to the consumers to pursue as a cause of action, to go to an attorney and pursue the consumer reporting agencies and the furnishers under certain circumstances, if they were willful or if they were negligent in performing their duties. So what I want to do here is give you guys just a quick visual, again, because I cannot drill home enough how the FCRA, although accurate information is super important for us disputing information on behalf of the consumers, if we're a credit repair organization, we need to stop looking at it like, oh my gosh, they're reporting inaccurate information and they didn't fix it. These people are terrible. Instead, we need to look at it like they're reporting inaccurate information and they didn't fix it. And these people are terrible because their procedures failed, because we gave them a reasonable dispute, right? The burden really starts with the consumer or the credit repair organization creating a well-crafted dispute, which then triggers the FCRA's reinvestigation and dispute provisions. And so if you just send them a letter, again, as I say, prove it or remove it, I mean, this could be really hard for you to go to a judge and be like, their procedures failed if you just sent them a one-sentence dispute that says prove it or remove it, right? I mean, of course, it's going to be the consumer's trade line, unless like it's a mixed file case. But if you say, hey, your information is wrong, particularly the following information is not reporting accurately, there's multiple different reports of balances, multiple different credit limits, multiple different highs, we're missing certain data fields, whatever. When you look at the data and find what's wrong with it, if you put that in a dispute, then that puts you in a much different position. So what we want to do here, again, to kind of drill home and help you visualize that we need to think more of the FCRA as procedure-driven and information-driven rather than just accuracy and truthful-driven. I want to take a look, and we're going to look here at the FCRA. This is the entire FCRA I've got pulled up here, and we'll enlarge it for a minute. And I've got this little search box here, and you can see I've searched for the word procedure. And you can see in the entire FCRA, the word procedure shows up 58 times. If you think that's a lot, wait till we look at how many times the word information shows up, okay? So this is the entire FCRA, and we can scroll through it, and you will notice we will shrink it down a little bit here just to make the scrolling easier. There is going to be yellow highlights all throughout here for procedures. Okay, if we scroll through the FCRA, because my point to you is that, see, there's yellow. The FCRA was designed to create procedures surrounding how the reporting of information or the telling of these stories is supposed to be handled. Okay, so the entire FCRA has procedures sprinkled throughout it. The other thing, if we look at the word information, okay, and it's in here 616 times. Now, this version of the FCRA is from the House, of the U.S. House of Representatives. It's got some annotated notes in here, which may have the word information apart from the actual FCRA. But the point is, 616 times the word information is throughout here. I mean, we scroll all the way down, and you guys can see literally everywhere in here is information. Think of information as stories, right? Telling a story about you, right? So what they're basically doing is they're saying, hey, again, why are we talking about this? Because they've removed defamation, negligence, invasion of privacy for telling a defamatory story. But instead, the FCRA replaces it with information and procedures designed to help the consumers and the consumer reporting agencies navigate through that information. So why is this important for those of you guys watching here, whether you're a consumer, whether you're a credit repair organization? It's important because this understanding will help you to more effectively put credit disputes together that have leverage to them In other words, understanding what it is that's going to cause some sort of a potential liability if the consumer reporting agencies and the furnishers do not properly respond to your dispute. And the frustration that I know a lot of consumers and credit repair organizations have is they'll talk to attorneys. And I also know a lot of consumer protection attorneys, and they have the reciprocal opposite frustration. They will get approached by a lot of consumers and a lot of credit repair organizations, and they will go to the consumer protection lawyers and say, hey, I think I've got an amazing case. This thing is totally wrong and jacked up. And then the attorney will look at the disputes that were sent, and they're essentially baseless disputes. There was really nothing of substance or factually sound about the disputes. So the takeaway here is, if you can realize that the FCRA essentially has information written in there over 600 times and procedures written in there over 50 times, the consumer or the credit repair organization representing the consumer has a certain duty to represent the consumer's portion of those procedures. It's important to understand that, because it's true that the consumer has no say-so in the original reporting of the information or the original telling of that story. So Congress puts the burden on the consumer. Well, first they place the responsibility on the consumer reporting agencies to assure that it's of maximum accuracy. That's part of the FCRA, but mistakes do happen. And so then they put the burden in general, in most situations, on the consumer to properly notify the consumer reporting agencies and give them enough information to reasonably reinvestigate. So what does this mean? Next time we're putting these dispute letters together, we want to make sure that we have something of substance to them. We want to have enough information for when the consumer reporting agencies receive it. If they don't fix it or delete it, you can easily point back and say, you know what, your procedures failed because we clearly gave you enough information to know why it was wrong and you didn't fix it. So that being said, I hope you guys get some good nuggets from this video. I hope this helps you to figure out how to structure more effective disputes with leverage. And we will see all of you guys on the next video. You guys take care.